Why, he doesn't have to identify himself at 2 o'clock in the morning walking down Wilshire Boulevard with a TV set. Now the police, I'm sure, hate that, and they're just sitting there probably straining at the bit and just cursing that Supreme Court up one side and down the other. But you know, if the police can demand of him to identify himself, well then can't they do that to you? Now some of you are going to say, well, what's so terrible about that? Well, nothing except that I didn't know that in America we had to carry our documents and our papers around with us like we do in Nazi Germany. And that fellow down there in Los Angeles, I wish I had his name. I'd like to make contact with him. I'd like to talk to a guy like that. I'd like to find out what he knows. I can tell right away he's smarter than I am. And when I see somebody that's smarter than I am, first thing I want to do is go sit down and pick his brain, see if I can't get a little smarter too. So when you're talking about constitutional issues, at the scene of the crime, the jailhouse scene, the motion hearing, everything you do is geared to creating that constitutional issue that will carry your case to the Supreme Court of the United States. This fellow did just exactly that. He got up at 1:30 in the morning. He went in his front room and grabbed a TV set. And he went out on the sidewalk and he started walking down the street with it. And the policeman stopped him. And he says, "Hey, you, identify yourself." And I don't know what the response was. It was probably something like, "Bug off, Whitey," or "Hunky," and "Get out of here," or whatever. I don't know what went on, but I'm sure there was probably some little discourse there. The policeman arrested him, took him off to jail. "Where's your documents? Where's your driver's license?" And this guy's walking down the street. He doesn't have a driver's license, Social Security. I suppose they ask him, "Well, what's your name?" "I don't want to tell you what my name is." "What probable cause do you have to believe that I'm a criminal?" Or "What probable cause do you make this intrusion into my private life? Has somebody reported a stolen television set? Why is it that you're stopping me in the morning?" Somebody just put a note on the desk here. His name is Edgar Lawson. Edgar Lawson. I remember that. If any of you down in Los Angeles have a TV, or have a phone book, why don't you call this Edgar Lawson? It'd be worth sitting down talking to him. I'll tell you, he's no dummy. I listened to him there on Good Morning America. It just blew my mind. I said, wait a minute, I can't believe this. You see, what he did is he set them up. He decided that he had a constitutional issue. He was tired of blacks being harassed walking up and down the streets because they're black. And I don't blame him. I do the same thing. I'm white, and I'm out here challenging police all the time. I don't tell them who I am. Problem is, they all know who I am now, and they don't bother me anymore. And half the fun, of this whole game is baiting the police and having them haul you off to jail, and just drives them up the wall. Now, there's two pieces of paper here that you have, and it's called Validity of Statutes. And it's called Section 3, Conditions Under Which Validity of Statutes Will Be Determined. Now, I'm going to go through these. There are 7. See what we got here. There are 7 reasons or 7 causes here that the Supreme Court will listen to an issue. Or, put another way, there are 7 no-nos here. If you don't conform to these 7 rules, your case will not be heard by the Supreme Court of the United States. So this is going to be one of the most important lessons you've got. Now, you may not be able to learn or remember all of these, but if you'll read through these in this lesson and then just go through them 3 more times, you'll get the principles down in your brain. You don't necessarily have to recite them. You don't have to sit here and say, I remember rule number 3 is thus and such, and then recite it off like you did in Sunday school when you were memorizing scriptures. But you'll have it in your mind that if you're not damaged by the statute, you don't have a cause of action. All right? Let's take a look up here at what's called, the first one, it's before number 1. It's called Ashwander versus Tennessee Valley Authority, 297 U.S. 288. Now, that case was decided in 1936. Now, here's Mr. Justice Brandeis concurring, quote, "The court has frequently called attention to the great gravity and delicacy of its function in passing upon the validity of an act of Congress that is determining the constitutionality of an act. and has restricted exercise of this function by rigid insistence that the jurisdiction of federal courts is limited to actual cases and controversies. Actual cases and controversies. And that they have no power to give advisory opinions. You know, I'd often wondered about that. Why doesn't the senators and representatives just walk across the street and say, how are you guys going to rule on this law? You tell us and then we'll pass the law. No, you guys pass the law, and then if some citizen out there doesn't like the law, let him bring it to us and we'll decide whether it's constitutional. Well, wouldn't it be a lot faster, simpler, and cleaner if Congress took it across the street? Do you know what that would do? That would make the court then a part of the legislative branch of government. They would be legislating, wouldn't they? And you can have unconstitutional laws, and the police can be out there enforcing unconstitutional laws. Until this guy Edgar Lawson came along, the police were down there demanding the documents of citizens of California. They just stop you and say, let me see your documents. That reminded me of the movie Casablanca, you know. The Gestapo comes in and they just tap everybody on the shoulder. Let me see your picture ID and let me see your identification. That same kind of Nazi philosophy is extant in the United States and every state in the Union. The only people in the United States that don't believe in that are the Supreme Court and a guy named Edgar Lawson. Everybody else just opens their wallet and conforms to the Gestapo and tells them, yeah, I've got my documents with me. I carry my papers. And that they have no power to give advisory opinions. On this ground, it has in recent years ordered the dismissal of several suits challenging the constitutionality of important acts of Congress. The court developed for its own governance, in the cases confessedly within its jurisdiction, a series of rules under which it has avoided passing upon a large part of all of the constitutional questions pressed upon it for decision. And they are. And here's rule number 1. So the Supreme Court has 7 rules by which they will determine whether or not they're going to listen to your case. And this fellow, Mr. Lawson from Los Angeles, conformed to all 7 of these rules. Now, I don't know whether he did it accidentally or not. Almeida Sanchez did it accidentally. Miranda did it accidentally. Escobedo did it accidentally. But you know, you as a citizen must do it purposefully and knowledgeably, because we don't have time to mess around and dink around. Learn the rules of the game, and then you won't have a problem qualifying your case. You'll know what to do at the jailhouse because you know the rules. You'll know what to do at the scene of the crime because you know the rules. Rule number 1. The court will not pass upon the constitutionality of legislation in a friendly, non-adversary proceeding, declining because to decide such questions is legitimate only in the last resort and as a necessity in the determination of a real, earnest, and vital controversy between individuals. It never was the thought that by means of a friendly suit, a party beaten in the legislature could transfer to the courts an inquiry as to the constitutionality of the legislative act. And there's a couple of citations from cases called Chicago and Grand Trunk Railway versus Wellman. And they took that case, that Grand Trunk Railway, and they came up with this rule. If you've got a friendly, non-adversary suit, we're not going to listen to it. That's where the legislature comes over, or some senators and representatives walk over to the judge and say, how will you rule on this legislation? Isn't it unconstitutional? We don't rule on things like that. Number 2, the court will not anticipate a question of constitutional law in advance of the necessity of deciding it. Remember, I've said that the Supreme Court's not going to come out to Idaho and make us shape up. They'll just sit back there in Washington and say, if you citizens out there in Idaho want to live under that tyranny, it's all right with us. Unless somebody wants to bring the issue to us to decide, we're just going to sit here in Washington and have a good time basking in the sun. It is not the habit of the court to decide questions of a constitutional nature unless absolutely necessary to a decision of the case. So if they don't have to decide the constitutional issue, they won't. And that comes from a case called Burton versus United States, 196 U.S. 283. So if you want to go check that case out and find out whether or not that's true, why don't you read it and find out what the court has said about the anticipation of a constitutional question. That's why in the case called Williams versus Florida, I noticed that Byron White said in there, I perceive that the question you wanted answered was. But that isn't the question you asked, so we'll save that one for another time. Okay? Number 3. The court will not formulate a rule of constitutional law broader than is required by the precise facts to which it is to be applied. Now, what the court is telling you then in plain, simple, easy to understand language, there could be 5 or 6 issues and a lot of ramifications out here. The court doesn't say, now we've decided that blacks cannot be excluded from this school, or that blacks, like on this bus, say in Alabama. They just made an exact determination based upon the question asked. The lady rode the front of the bus, the lady was put in jail, she was prosecuted, and when it was all said and done, the court made a ruling, and they said blacks may not be, I didn't see the exact ruling, but they'll say something like, blacks may not be excluded from the front of the bus. Well, they don't sit there and go on to say, and blacks cannot be excluded from the front of the trains, and blacks cannot be excluded from this or that. They'll answer just exactly the question that's asked and nothing more. And sometimes my students say, well, that's insane. They should go on and expound and explain how that's got to be. No, they shouldn't, because if they did that, they would be exercising the powers of the legislature. It's up to the legislature to pass laws and say that the blacks will ride the back of the bus in the last 4 seats and they shall not ride the front of the bus. It's up to the legislature to spell out the terms and conditions of the law. Then, when you take that law and put it next to the Constitution, the Supreme Court says, the law says, blacks shall ride the last 4 seats of the bus. Okay. That's unconstitutional because it's discriminatory. And that's all they'll decide. They won't sit there and talk about Indians riding the back of the bus or some other racial group riding the back of the bus. Just exactly, I think they probably would put in there. And no one can be segregated because of his race, religion, or color. And that's the end of the argument. That's all they're going to decide. If you want to know about trains, you're going to have to sue. You're going to personally have to go take that issue in. And another thing is that because the court rules that a law is unconstitutional doesn't mean that they're going to order that it be taken off the books. The Supreme Court can't order the legislature to take a law off the books. We got a case right here in Idaho where a guy was convicted in 1978 for lewd and lascivious conduct. Our state Supreme Court struck the statute down. It hasn't been removed from the books to this moment in time. It's been declared by the court to be vague, ambiguous, and overly broad. And the same man was arrested 3 years later, tried and convicted, and he's sitting out in the penitentiary under the very same law. Okay? Court isn't going to compel the legislature to take it off the books. I don't know what his defense is. I think he ought to be double jeopardy. I think he ought to raise a Title 42 suit. I don't know what he's going to do. All I know is that it isn't the function of the judicial branch to act in a legislative capacity. Number 4, the court will not pass upon a constitutional question, although properly presented by the record, if there is also present some other ground upon which the case may be disposed of. Boy, if you don't think that's a real eye-opener. So here you go into court and you've got all of these briefs and motions into your record, and you're arguing, let's say, the counsel issue, and you're arguing rights that have been violated in some other way, and procedure, and evidence, and grand jury, and information, and one thing and another. And in the record it would show that a little minor rule of procedure was violated. The court can decide the issue on the rule of procedure and never address the grand jury or anything else. They don't have to. And they say right here, If there's any other ground upon which the case may be disposed of, we'll do that. This rule has found a most varied application. Thus, if a case can be decided on either of two grounds, one involving a constitutional question, the other a question of statutory construction or general law, the court will only decide the latter. If they can look at a statute and say that the statute fails for this or that reason, then they won't address the other constitutional question of the grand jury or of some other rights issue. But then, of course, in your case, what difference does it make to you? You've won your case. But the next man and the next man and the next man has got to go into that courtroom and he's got to argue his position. That's the way Republican government works. You, the individual, demand your rights. What we have is mobocracy. What we want is the civil law, and we want to hire lawyers and solicitors to go into court and do the job for us. What we want is to join the union and sign the contract, and then the union will go negotiate with management. We've got the groupies here in America. I think we need to get rid of this groupieism. I don't need anybody to negotiate with me. I can do all right by myself. Appeals from the highest court of a state challenging its decision of a question under the federal Constitution are frequently dismissed because the judgment can be sustained on an independent state ground. It can be decided on a state issue, a state statute, and they're not going to rule on that in the Supreme Court. Okay? Number 5. The court will not pass upon the validity of a statute upon the complaint of one who fails to show that he is injured by the operation. And boy, let me tell you, we've got a real problem coming up. Out in Ohio, not Ohio, it was Illinois. Now look at that rule number 5 and then listen to this, and I'm going to tell you, we're going to get a decision on guns that is going to be a renvoy on our Second Amendment. And here's what's happened. Some guy out in Marion, I guess it is, I think it's Marion, Illinois, and some little town out there, they passed a gun control ordinance, and they forbid the sports stores in the town and the citizens to have pistols or guns. Some lawyer back there, God bless him, you know, always leave it to a lawyer, he sued and claimed that his rights were violated, and he argued it in the district court, and they said, no, that city ordinance is constitutional. Then he took it, and he's now, I think, at about the state Supreme Court level. The appeals court has overruled him, and now he's going to the state Supreme Court. Now, fortunately, in California, that San Francisco ordinance was thrown out. I don't know the facts of it, but I'm going to show you what's going to happen here. This guy hasn't been damaged by the statute. This is a friendly suit. Remember, can't have those. There's got to be a controversy. If it does go to the Supreme Court is going to rule there's nothing unconstitutional about the city passing gun control legislation and compelling the citizens not to have guns. The question is, can they enforce it, not whether or not they can pass it. Certainly they can pass it. But if they enforce the statute, will it violate somebody's rights? What the guy should have done is to walk down Main Street with a .45 on his hip and challenge the police chief to do anything about it. Then the police chief would have arrested him and taken his gun from him and put him in jail. Now the operation of the statute would have damaged him. You see what it says here? The court will not pass upon the validity of a statute upon complaint of one who fails to show that he's been injured by its operation. This guy's never been injured by the operation of that ordinance or statute in that city. He's filed a friendly suit in violation of a number of Supreme Court decisions that have already been settled. I can tell you in advance how the court's going to rule. The court's going to go out here to these cases called Columbus versus Greenville Railroad versus Miller, and they're going to cite these cases, and they're going to say, well, this issue's already settled. So he's bringing guns in, not following the rules, and then watch the newspaper headlines say, Supreme Court upholds gun control ordinances. And you'll have a rash of gun control ordinances nationwide. And then, of course, all the sheeple will turn their guns in like they have in Massachusetts and New York because the issue's never been correctly argued. It's like the money issue. It's never been correctly argued. We've got a lot of tax strikers out here screaming Article 1, Section 10, but they don't follow the rules here. If you want to follow the rules, you've got to be damaged. You can't go into a court and argue Article 1, Section 10. You can't go bring constitutional issues up until you've been damaged thereby. Now, I've been damaged a couple of times, but we're not really sure whether we're ready to move that money issue into the higher courts yet. We're studying that. And I'm not even claiming that I'm competent to argue a case to the Supreme Court, but I'm smart enough to look at the rules. I might not know what it is that I need to do or how I'm going to argue my case to the Supreme Court, but I can read the rules and find out what I can't do. It's like I've said before, I don't know what I am, but I know what I am not. I am not a prophet. Okay, so we know what I'm not. Now we've got to figure out what I am. Going on, among the many applications of this rule, none is more striking than the denial of the right of challenge to one who lacks a personal or a property right. That was the mistake made in Stewart Machine Company in 1935 when they challenged Social Security. The person who brought the suit didn't have a personal or a property right, and the court made one little blurb in there. If Mr. Davis were an employee of the company, he might have some standing. That's the thing that gave me the clue on Social Security. Social Security's never been decided. Nobody's ever asked the question, can a worker be compelled to pay into Social Security? I'm sure the High Court would say no, can't do that. But then that question's never been asked. No employee's ever brought it up. No employee wants to bring up that question. He just wants to get on the dole and collect. He doesn't care how it's paid in. Thus, the challenge by a public official interested only in the performance of his official duty will not be entertained. The court affirmed the dismissal of a suit brought by a citizen who sought to have the 19th Amendment declared unconstitutional. In Massachusetts v. Mellon, the challenge of the Federal Maternity Act was not entertained, although made by the Commonwealth on behalf of all of its citizens. You've got to be injured or damaged by its operation. When that policeman throws you in jail, that lady on the front of the bus was thrown in jail because she wouldn't ride the back of the bus. This man, Mr. Lawson, was arrested and thrown in jail for walking down Wilshire Boulevard at 2 o'clock in the morning with a television set in his arm. So what? Did he steal it? We don't know. In his case, no. So what the police are saying, anybody who walks down the street in a white neighborhood who's black carrying a color television set is obviously a thief. That's their position. And this man was damaged thereby, and that's why he got his case to the Supreme Court. If he hadn't been damaged, if he'd have filed suit and said, well, can they do this? Can they check identification? The court would have said, we're not even going to listen to it. And if they did listen to it, they'd say, certainly they can check identification. When were you ever damaged by them checking identification? Number 6, the court will not pass upon the constitutionality of a statute at the instance of one who has availed himself of the benefits. I don't know how many people I run across who will sit there and tell you, well, this is unconstitutional and this is bad and wrong and terrible, and just, paw the ground and bite the bushes. But they've still got the driver's license. They're still paying their Social Security. They're still paying their taxes. You've got to be damaged. What you've got to do is you've got to stake out your turf in a good faith effort. I sent my driver's license back. I said, this driver's license violates my rights, both the 4th and 5th Amendment, and I'm not going to sit still for that. And I'm moving it slowly but surely up through the judicial process. And I've been damaged thereby. They have thrown me in jail, and they've stolen my car. So it may take me 3 or 4 years to accomplish what Mr. Lawson has accomplished, but I want you to know that this guy is, to my knowledge, not a lawyer. This guy is a citizen who's a good, competent pro se, and he just took an issue and he said, I'm going to go argue this. And he did it, and he did it successfully. And you can do it. If this guy can do it, you can do it. I'm dumb as a post. If I can do it, most any housewife can do it. But you have to know the rules, because if you don't play the game by the rules, You'll get about 90% of the way to the Supreme Court and get knocked down because you've availed yourself of its benefits. If you've got a driver's license, don't go into court challenging the validity of driver's licenses in your case. If you got registration on your car, don't go in there and argue registration. If you're paying your taxes every year, don't go in there and start arguing your rights to taxes. You've got to stop paying the taxes and you've got to be damaged. Otherwise, you're not going anywhere. Now you can sit there and say, well, it shouldn't be that way. Well, I don't know how it should be. I'm just telling you that's the way it is. And if you want to go anywhere, you better do it according to these rules or you're not going to go anywhere. It's just that simple. If you want to change the rules, then that's another subject matter. Go up here and petition your senator. Number 7. When the validity of an act of Congress is drawn in question, and even if serious doubt of constitutionality is raised, it is a cardinal principle that this court, that's your Supreme Court, here's a cardinal principle of this court, will first ascertain whether a construction of the statute is fairly possible by which the question may be avoided. That's right, friends. The court will avoid that question like it's got bubonic plague all over it, if they possibly can. And yet that very same court, I think it was in Marbury versus Madison, said, when the jurisdiction is correct and when that issue is brought squarely before us, we must make a determination. Absolutely have to. We can't avoid it. But they'll avoid it if they don't have to. And so you've got to ask your question, which is what Williams failed to do in 1970 or 72. When the judge said, we perceive that the question you wanted to ask was, but the question you did ask was, does a 6-man jury violate this defendant's due process rights? No, it doesn't. Next. Oh, but what about the jury issue? You didn't ask us about the jury. That's not the question. The question was due process, and that's the question you asked, and that's the question you answered. Now do you see why it is we've developed this strategy? You know, I drive in and they'll say, how are you today? Oh, I'm pretty good today. And the conversation will develop, you know, and they'll ask a question. And when they ask the question, I just answer it. Are you going to court today? Yeah. How long are you going to be in court? I don't know. Oh, well, what court are you going to? District court. Is that the one downtown? Yes. What judge? Smith. In other words, I can just answer questions. Maybe what you wanted to know was, what are you going to do in court today? Well, you haven't asked that question yet. When you ask me, well, what kind of a case is it? Traffic. What kind of a hearing is it? Oh, glad you asked me. It's a motion hearing, suppression hearing, trial, arraignment, bail setting. You ask a specific question and you will get a specific answer. Now, I don't know if that's right or wrong or good or bad. You know, I drive my wife and my kids right up the wall. You know, they'll come home and they'll sit down at the dinner table, and my kids, you know, go to the government schools. They're handicapped also. I was handicapped, and I don't see no reason why I shouldn't handicap them. Why would I want to give them some kind of an opportunity or benefit that I myself didn't have? You know, I suffered through my government schools. My kids are going to have to suffer. They can't talk. They come home and they use the street language all the time, you know. And I just sit there and answer their questions. Can I go to the movie Saturday? I don't know. But Daddy, Walt Disney is on. Oh, that's nice to know. And I'll be sitting there eating. So why can't I go to the movie Saturday? I didn't know you couldn't. Well, you said I couldn't. When did I say that? Well, just now. I said you couldn't go to the movie? Yeah. I don't recall that. If I said you can't go to the movies, I'm sorry. I didn't mean that. Well, what did you mean? I didn't mean anything. You've never asked me a question yet. Well, I asked you if I could go to the movies Saturday. That's what I thought you asked. And I thought I answered it. Did I stutter? I said, I don't know. See, the question is, may I go to the movies? Daddy, may I have your permission to go to the movies? Yes, you may. Oh, thank you. And then they'll stand there and they'll, well, I don't have any money. Oh, well, that's too bad. I guess if you don't have any money, it'll be difficult to go to the movie. Oh, now I can't go to the movie. I don't know whether you can go to the movie or not. Well, and here's your poor kid. You know, he's gone to the government schools, and he can't ask the question, Daddy, will you give me $1 so I can go to the movie? Oh, you need money. Oh, certainly. Yes, sweetheart, you can have $1. Okay. Well, that's the way the court works. Now, what my kid really wants me to do is to figure out what it is she wants. Daddy, can I go to the movies Saturday? Oh, yes, sweetheart, yes, you can go to the movies, and you're going to need some money, and let me give you some money for the movies, and then you're going to need money for popcorn in there too, aren't you? And so here's some money for that. And probably the rest of your brothers and sisters want to go to the movies with you. Isn't that right, children? And so here's some more dollars for you children. That's what they really want me to do. But that's exactly what the Supreme Court will not do. They're not going to sit there and figure out what it is you want to ask. If you can't ask it, they can't answer it. And that's what they're telling you here in these rules. You're going to ask the question and they're going to answer it. Just exactly in a very narrow construction as to what it was you asked, they are going to answer. Nothing more, nothing less. They are not going to answer any hypothetical questions about is this constitutional or not. That isn't the issue. Don't attack the statute, friend. When you make your demand for your constitutional right, that statute probably applies to somebody. I'm challenging this driver's license as it applies to me. I'm not challenging the driver's license as it applies to you, mister, because I don't know about you. You may need a driver's license. You drive for Garrett Freight Lines? Yeah, you better have one. Can the state regulate Garrett trucks on the road? You bet. Do Garrett trucks have to have license plates? Every one. Do they have to pay all of their fees? You bet. Do they have to pull into ports of entry? I'll say they do. Well, then doesn't that apply to you? Not me. No, sir. I come under Hale versus Hinkle. There's a clear distinction between a corporation and me. I don't have to carry papers. I know who I am. You know, when somebody says, who are you? Who wants to know? Well, why are you so truculent and belligerent? Why are you so nosy? I didn't ask you who you were. I didn't tell you to identify yourself. I didn't ask you for your identification. I didn't ask you for your Social Security number, driver's license, and marriage and birth certificates. It's none of my damn business. And I'm smart enough to know that that's none of my business, and so I'm not rude like you are and going around asking people rude and nosy questions about their personal, private affairs. But I notice people don't have any shame whatsoever. They come up to me and they ask me all kinds of personal questions like, where do you live? What do you do for a living? How much money do you make? Do you pay taxes? Well, who in the hell's business is that but mine? And if I want to share that information with somebody, then I'm doing it because you're my friend and I want to share that information with you. You know, the Supreme Court understands the Fourth Amendment probably better than any of us. They understand privacy. Policemen don't understand privacy. And I suspect a lot of lawyers and a lot of lower court judges don't understand privacy, and they don't understand the Constitution, and they don't understand the way constitutional construction works. They don't understand the rules for getting your case to the Supreme Court. I may not get my case to the Supreme Court, but I'll guarantee you this. When I fail about the third or fourth level, I'm going to flip out my pen and I'm going to note that down and say, okay, now let's go back to the square one and let's get it right this time. It may take me 4 tries to get it there, but ultimately I'll get that case to Washington. I'll stay on that case until I succeed. All right. So I want you to run over these conditions under which the validity of statutes will be determined, because there's your 7 rules, and I didn't write these, friends. That's your Supreme Court. Don't get mad at me. If you don't agree with the rules, why don't you write a letter to Chief Justice Berger and complain about it, tell him you don't like it, and it's bad and wicked, terrible and awful, and he ought to change the law. That's what the President told him. you ought to change this exclusionary rule because we don't like it, and I hope the court tells them to stick it in their left ear. The court is an independent third branch of government. The court will decide what its rules and procedures are, not the Congress, not the President. And what we need to do is to encourage our judges to be independent thinkers. You know, I've got judges that I talk to from time to time. They're afraid to make judicial determinations. I had a judge actually tell me over lunch I would never make a decision like that. I am not going to rule on the money issues. Oh, I say, you just want to get your paycheck every week. Isn't that the way that works? You're working for mammon. Isn't that a fact, Judge? You do what you're told, so therefore you're not a judge, you're a clerk. Isn't that a fact, Judge? Isn't that a fact, clerk? When a judge says, I concur with Judge Smedley over here. Did you read my paper? Well, yeah, I read all your paper, and I think Judge Smedley is correct. What do you think? Why don't you think for yourself for a change? Maybe Smedley made a mistake over there. Why don't you correct it? Why would you need to put your stamp of approval on some other judge's error? Why don't you think for yourself and correct his error? You know, Judge Warren one time said that they've got a lot of Mickey Mouse cases coming up to the Supreme Court, and I agree with him. I don't see any reason why these cases that I'm bringing shouldn't be decided right here at the magistrate's level. I don't think in 5 years I've brought a case up or an issue up that warrants the merit or consideration of the Supreme Court of the United States. I haven't even raised an issue that would merit determination by my state Supreme Court, for crying out loud. Every issue I've brought up concerning driver's license, registration, proof of insurance, every case, every issue that I have ever raised has already been brought up by the Supreme Court and settled. It's been brought to the Supreme Court, I should say, and settled. All I'm doing is saying the Supreme Court says this, and I want to exercise this right, and I want you judges to affirm this, and I want you to tell that executive agency over there to get off my back. And they won't do that. So it leaves me no choice. Now I've got to take it to the next higher court. Do you see what the court has ruled here? Well, I'm not going to make that decision. Well, I'm not going to rule on those kooky issues. So you're going to continue to be a tyrant, and you're going to continue to oppress us. Is that what you're telling us, Mr. Law Clerk? That's exactly what you're getting out of your traffic courts, and it's about time you got in there with motions of substance and briefs that have substance and meaning to them. And I'm contending that when I bring a brief or a motion into court, it's not George Gordon speaking, it's Oliver Wendell Holmes. It's Marshall and Blackstone and Koch and Jay. It's not me. I'm not smart enough to come up with those lines. That's where the authority comes in. The issue, the argument, and the authority. And my authority comes from Washington, D.C. My authority comes from Blackstone. My authority comes from Koch. My authority comes from Holmes. Now, where does your authority come from, Mr. Prosecutor? Where does your authority come from, Judge? Give me a meaningful rebuttal. I want to hear your argument. I want you to show me about what it is in my motions and briefs that are incorrect. Prove it to me. All right? I think that's lesson 13, and I think we've hashed that over. Take a look at those 7 rules. That's the most important portion of this entire motion issue that you're going to see. Now we'll take up in the next lesson this thing of suppression of evidence and sua sponte and a couple of sample rules.